So, in the last event in this series, I talked a little bit about what happens with incoming requests to Ireland for data disclosure. And this is a development of that. And in this, I want to talk a little bit about how Irish law deals with some types of requests, both domestic and incoming from other jurisdictions. And those are in relation to digital searches. So the carrying out of the execution of search warrants against computers, mobile phones, etc., the issues that these present, and why we need to think about them in a little bit more detail in an Irish context. So there are 4 points I want to make to you. One that I don't think would be particularly contentious for anybody here is that digital searches are in fact different. They are searches which involve accessing quite a bit more data than other searches do. They are considerably more invasive in many regards. The second point then is that Irish law has failed to adequately regulate them. We'll see why. The third point then is that while we see proposals underway in Ireland to address this, that we as of yet don't have proposals which really address the problems that are arising. And then the fourth point is that we have some concrete examples of the kinds of problems that are arising in a few cases. We can tease out more, and we need to consider these when we look at the reform of Irish legislation. So why are digital searches different? Well, you don't have to trust me in this regard because judges from a number of different Supreme Courts around the world have accepted this. Notably, the US Supreme Court in Raleigh in California, restricting search of mobile phones incident to arrest, pointed out that searches of mobile phones are different because they contain so much information about you. They contain so much in the way of details about your life. It is a broad array of private information never found in the home, so that the search of the phone is in many ways more invasive than the search of the home itself. We see a similar point made by the Canadian Supreme Court when they point out that the volume of data stored, generated without your knowledge on computers, on mobile devices, means that searches of them should be specifically authorized. They shouldn't be subsumed into search warrants which simply specify the search of a place and not the search of a computer itself. So I think there is no great controversy about this point. Digital searches are different. They present many issues of privacy. They present many issues of practical enforcement. I say that Irish law in relation to search warrants doesn't at the moment adequately address these differences. Why not? Well, a difficulty here is that there is a huge range of different search powers in Ireland. And there is no unified search warrant legislation. Instead, the nature of each power depends on the particular crime being investigated in a particular place. And that in turn determines who can issue the warrant in respect of what type of crime, in respect of what type of premises, what type of powers attached to that in relation to, for example, the disclosure of passwords or the unencryption of documents. And as Dermot Walsh puts it, this is an unwieldy collection of disparate provisions. So it's very hard even to survey all the statutory powers in this area, let alone to give a conclusive assessment of how they're being used. But what we can say is that a number of more modern powers, which do specifically address the issue of accessing data, have been very problematic indeed. So why is that? Look at the model introduced here by Section 48 of the Criminal Justice Theft and Fraud Offences Act 2001, which is a model that's been followed by most recent legislation in this area. So this provides that in relation to crimes under that act, which can include crimes as basic as simple theft of a low value item, search warrants issued under that provision will include a power of members of the police force executing them to operate any computer at the place being searched, to require any person at the place being searched to hand over the password to operate that computer. And indeed, it goes further to define computers at the place being searched so widely as to include computers anywhere else in the world if they are lawfully accessible by means of that computer. So hold that thought, because that is going to be particularly critical in a moment. What are the implications of the Section 48 power? Well, first of all, notice what it doesn't have at the point of issue. So there's no requirement in Section 48 that the court consider the proportionality of issuing a warrant, or the proportionality of the use of these powers under the warrant. There are arguments in some later cases that you can, to an extent, read in such a requirement, but certainly it's not expressly set out in the statute. That creates a second difficulty, which is that all of these really quite intrusive powers are bundled into every Section 48 warrant by default. Every warrant comes with this power to examine, operate, seize computer data, require people to disclose passwords and so on. This isn't a power which is handed out on an assessment of proportionality or necessity in an individual case. It's also a power, incidentally, that applies to all devices at this particular place and to every individual at this particular place. So it's a power which could apply to, for example, the roommate of a person under investigation in the case of shared accommodation. The legislation doesn't provide for the issue of self-incrimination. As you are probably well aware, there is an exhaustive debate in other jurisdictions as to whether compelled disclosure of passwords can amount to self-incrimination. Nor does it set any other threshold of necessity or gravity for this. And in this regard, it contrasts with, for example, the UK position, where, as you're probably aware, we don't have blanket rules requiring disclosure of passwords. Instead, disclosure of passwords has to be adjudicated on a case-by-case basis, where a judge finds that it's necessary and proportionate for a particular interest, such as national security or the prevention or detection of crime. So again, we don't have that. We have a blanket power in this case. And then we have this point about the definition of computer, including computers other than those at the place being searched. So any other computer anywhere else in the world which is lawfully accessible by means of that computer. And this, to me, presents an obvious problem here, which is that it, in effect, opens the door to cloud searches, to remote searches of any computer attached to that computer, if a device is logged in, for example. Indeed, any other computer at all. And if this looks familiar, you may be thinking of the power to conduct remote searches under Article 32 of the Cybercrime Convention. But of course, Ireland hasn't ratified the Cybercrime Convention. And in any event, Article 32 applies only to remote searches with the consent of the individual entitled to consent. It wouldn't have any application in this case. So this presents obvious comity issues here if the remote search power is used in a way that would violate the law of the territory where the computer is actually located, and more of that anon. So what about this requirement to produce a password? A troubling element of it is that the requirement is to produce a password there and then. So the failure to do so amounts to obstruction, unless you can show an excuse, which is not defined in the legislation. And it's a serious criminal offence in its own right. And because of this definition of computers as including computers at other places, this seems to include within it a power to demand passwords to other services, cloud services, your Google Drive, your Gmail account, etc., which presents obvious security issues if you're requiring users to hand over data which can be used to, for example, generate authentication keys, authenticating messages from them. Now, there is a limited safeguard in that section for privileged material, but it's limited to legally privileged material. And it doesn't explicitly address the issue of screening of seized material. So it rather leaves open the question of what is to happen when there is an allegation that certain material on a device is privileged. What are police to do if they, for example, seize a phone and the individual says, hang on, I have a number of WhatsApp messages to my lawyer on that phone which are privileged. And then crucially, there's no provision at all regarding other kinds of sensitive information, such as journalistic sources, which are left entirely unregulated. So my first point then is that that kind of power, which is now becoming common in Irish law, is problematic. My second point is that we have a number of cases and experience beginning to throw up the kind of problems that power creates. A very good example of this is in the rather difficult case of CRH and the Competition and Consumer Protection Commission. This involved an antitrust investigation being carried out by the Commission into the CRH group, And in relation to one company in particular, Irish Cement, a warrant under the specific statutory power of the Commission was executed, under which the Commission took the entire email account of a particular executive. And the company, the executive, challenged that, saying, simply put, that this was beyond their statutory powers, that the vast bulk of the emails in that account were entirely unrelated to any matter under investigation. And the High Court and the Supreme Court agreed, but that presented then the question, what was to happen to the data that had been seized on foot of that power? Was it possible, for example, for that data to be screened by an independent third party to pick out that information that was relevant to the investigation? Well, the statutory power creating this warrant power didn't address the question, and the Supreme Court in effect kicked the matter to touch by requiring the parties to agree amongst themselves a protocol for how all this information could be screened. And to my knowledge, they never in fact did so, and the investigation concluded without that information ever actually being accessed because of the difficulty presented by this. You see a similar problem in relation to journalistic sources in the Corcoran case. In this case, we have an attack on security men who are guarding a farmhouse from which farmers have been evicted. And a journalist apparently gets a tip off that there's going to be an attack on the security guards, attends the scene, takes photographs, videos of the attack, and police later ask the journalist to provide information and to hand over the mobile phone for examination. When they fail to do so, when they refuse to do so, Garda obtain a warrant against the journalist on an ex parte basis, without the journalist being represented, requiring him to hand over the mobile phone. So the question presented when the journalist brought a challenge to that warrant was whether or not such an order could be valid, where it would oblige him to disclose the identity of a source, in effect. And the High Court had some difficulty assessing this claim because the legislation was certainly defective in that, contrary to European law, contrary to the requirements of the ECHR, it didn't provide for any judicial assessment at the time the warrant was issued as to whether or not it was proportionate and necessary to identify the source. The court declined to read in such an assessment into the power to issue a warrant. It was only by happenstance in this case that the phone happened to be encrypted, so that the opportunity came for a court to consider this matter before police actually accessed the data. Now, in the end, the court again somewhat sidestepped the issue presented by finding that on the facts of the case, journalistic privilege, or the entitlement to protect a journalistic source, would not apply in any event. But having said that, it then made a very interesting order, which was that police would be entitled to inspect the phone, but only in relation to certain material over certain dates, in effect imposing an after-the-fact screening obligation on police, which in a way which isn't provided for by legislation. So you can see that as the court attempting to work around the deficiencies of the legislation. A third example comes from a recent Irish report, a report produced by Irish authorities for the mutual evaluation process, where the European Commission and Council are facilitating evaluations of member states' responses to cybercrime. And that refers to the power to compel disclosure of passwords that we've mentioned in Section 48 of the 2001 Act and in other legislation. And it makes a very interesting observation, which is that prosecutions for this, prosecutions for failure to disclose passwords, don't appear to be being brought. Why not? Because there is concern that the right against self-incrimination precludes such prosecutions. So on the face of it, we have a statutory power on the books, which, as far as I'm aware, doesn't appear to be being used. And certainly there's no reported judgments on this point. So we also have current proposals to reform the law in relation to search warrants, and it's my argument that these don't go anywhere near far enough in addressing these concerns. The background here is that in 2015, the Law Reform Commission published a report on search warrants, which essentially recommended extending the Section 48 type powers to all offences. But it did so without considering really any of the points that I've discussed so far, the comity, self-incrimination, privacy and proportionality points. And it didn't engage with any of the literature from other jurisdictions where these issues had already been arising. And you can see the issues that presents if you look at the Garda Powers Bill 2021, which proposes to implement those recommendations. Head 16 of the Heads of Bill proposes to basically extend the Section 48 model to all search warrants, which broadly speaking would mean that any investigation of a crime under Irish law, which is a serious crime, so it's a crime carrying a possible 5-year prison sentence, would automatically carry these powers. So the powers to inspect and seize data, the powers to require passwords and so on. But indeed, the proposal goes even further again by making it clear that you can, if you like, daisy chain the search. If you find a password on a device being searched, you can then use that password to log into a further service. So if a Garda sees your computer and they find on that a stored password for your bank account or for your Google Drive, they can then in turn take those passwords and examine those further services. And that's compounded by an additional provision which explicitly envisages remote searches, with the curious qualification that a search warrant is primarily for the search of a place. But despite that acknowledgement, it goes on to say that it allows the disclosure of information that is under somebody's power or control, notwithstanding that it's located somewhere else entirely. So again, I think quite a problematic power. Do we have any greater protections then regarding the use of seized material, the kind of material that might be seized? Not really. We do have a greater carve out in relation to privileged material and a system whereby a judge will assess claims of privilege. But there's no similar power or restriction in relation to other claims, such as claims of so-called journalistic privilege, source protection, or material which is particularly sensitive or private for other reasons. And interestingly, while there is an explicit power to seize mixed material, so a server or a computer which contains both relevant and irrelevant material, there is no provision in the legislation for how that material should be dealt with after it is seized. Instead, the legislation appears to regard this as simply too difficult to deal with and proposes that it would be addressed in a code of practice to be adopted at a later stage. Unfortunately, that code of practice would not have any binding effect. It would not be provide, for example, for an exclusionary remedy if it were breached. It would only provide for a disciplinary remedy against the relevant member of the police force. Remarkably, the legislation continues the practice of allowing for so-called self-service search warrants issued by police in cases of urgency rather than by judges. And those self-service search warrants would carry the same range of powers as judicial warrants would. And indeed, in some cases, statutory bodies, notably the Consumer and Competition Protection Commission, the Office of the Director of Corporate Enforcement, would be able to seek search warrants bearing all these powers, even in cases where no offence is suspected. So I would suggest that we need to go back to the drawing board in this regard. And there's a very good comparator here from the English experience, where the Law Commission in its 2020 report on search warrants identified 4 key areas which legislation needs to consider. 4 key issues which legislation needs to consider, and then 3 key areas where legislation needs to respond. The 4 key areas are what make digital searches different: the volume of the data that can be searched, the likelihood that irrelevant or protected data can be viewed and seized incidentally in some cases, the fact that these searches often cross jurisdictional boundaries, and the fact that an individual might not be aware that such a search of their cloud storage, for example, has taken place. And the Law Commission identified then 3 key areas where safeguards could be built in to address these points. You can build in additional criteria at the application stage. So you can require, for example, greater assessment of proportionality or the type of searches which are permitted. You can improve on the requirement of specificity. One problem here is that the requirement that search warrants be specific as to what is to be searched is often met by the so-called single item approach. A search warrant which says the entirety of a phone can be searched, for example, is specific only in a rather technical sense if it doesn't specify a date range or type of file or some other criterion to specify what part of the phone storage is relevant. And thirdly, the Law Commission suggested that the law should specifically regulate treatment of devices and data post-seizure, introducing, for example, greater screening obligations in respect of seized data. And while you might disagree as to the extent to which all of these safeguards should be put in place, a difficulty in the Irish context is that, as things stand at the moment, none of these obligations have been put in place. So to wrap up then, the Garda Powers Bill that I've described to you there will be undergoing pre-legislative scrutiny before the Oireachtas shortly. There is certainly a need for greater rationalisation and consolidation of Garda Powers in this area, but it's my case that doing this by simply extending the existing power will certainly violate fundamental rights, and that aspect of the bill needs to go back to the drawing board. Fortunately, we are seeing some public debate about this. These are articles written by one by myself, one by one of our colleagues in the news, addressing aspects of this, but I think we really need to consider this somewhat further. Thank you very much.